is lesson 8, chapter 27 of your textbooks, page 598, the rights of the child. The rights of the child in South Africa is found in section 28 of the Constitution, and this section is based on the rights of the child as this is section 28 of the Constitution, which contains the rights of the child. As you can see, Section 28.1 starts with every child has the right. Then they have a list of rights. Then we have Section 28.2, which contains the best interest principle and right of the child. And then Section 3, which defines what a child is according to law, which is any person under the age of 18 years. So what this tells you is all the rights we find in Section 28 will only be applicable to people under the age of 18 years within South Africa. Now, Section 28 gives additional protection to the rest of the Constitution. So it means that children have all the rights in the Constitution. They are applicable to them in every aspect except for rights, for example, the right to vote or the right to stand for public office, which is obviously restricted to an adult child. But other than that, every child enjoys the same protection through the Bill of Rights as does any adult. These include rights like the right to reproduction, reproductive health care, dignity, privacy, not to be discriminated against on grounds of sex and birth or their parents' nationality, and their right to access to courts. Regarding reproductive rights, it means, for example, that a child has the right to an abortion. This is obviously within certain parameters, and their guardian and an adult will have to be a part of this, but in no way is a child's right restricted just due to their age. In addition to this, the children's rights under Section 28 are augmented by certain other rights. Now, what does this mean? For example, if we take Section 28C, the right to basic nutrition, shelter, basic healthcare services, and social services. This right is very similar to other rights we find in the Constitution, namely Section 26 and Section 27. Now remember, Section 26 and Section 27 are rights in the Constitution given to all citizens in the country. Section 26 and Section 27 actually contain the same basic rights, the right to housing, social services, food, etc. But what we have here is Section 28C places these rights and gives them specifically to children. So what we're saying is Section 28 is supporting or augmenting rights we find in other places in the Constitution. So what Section 28 is telling us is children have all these rights adults have, but we want to place emphasis on the fact that there are certain rights that they specifically have to have. So it supports, these two support each other. The rights in Section 28 also support each other. If you look at Section 28B, it says that every child has the right to family care, parental care, or appropriate alternative care. Now, if we read Section 28C, it places a duty on the state to ensure that a child is provided with these basic requirements in Section 28C, but also for the state to then support the family of the child with the means to meet these requirements. And that is why we have something like a social grant system, where money is given by the state, or grants are given by the state to families of children in the case where they don't have enough money or the means to provide their children with Section 28C. Currently, our grants are very low. It's something between 700 and 900 Rand, if I'm not mistaken. But that is what the state can at this stage give to help families in parental care to actually accomplish giving children basic nutrition, shelter, etc. Now, Another section we can look at is section 8, which is the application clause. This provides that the rights in the Bill of Rights will bind all natural persons, should the nature of the right permit. So how does section 8 and section 28 link with each other? Now this creates a direct horizontal application. What do we mean by this? If you look at section 28, it's obviously the rights of a child. But if you look at the individual rights, do you think a child will be able to provide these rights to themselves? Can a child of 7 guarantee nutrition or shelter for themselves? No, they cannot. If you look at section 828D, for example, the right for a child to be protected from maltreatment, neglect, abuse, or degradation. If we look at this, it's obvious that there's another party that forms part of section 28, and these are the parents of a child. So what the combination of section 8 and section 28 creates is a horizontal application between the parents of a child and the Constitution. So it places a constitutional duty on the parents of the child to provide for the child's basic needs and not to abuse, exploit, or require the child to perform unsuitable or unhealthy work. In order for the Constitution and Section 28 to be applied and for children to have access to this right, new legislation were given effect after 1994. Now, these legislation clearly sets out the rights of children and the responsibilities and the rights of parents, the state and other duty bearers in relation to all these rights. These laws largely reflect the Constitution as well as international and regional instruments which South Africa has ratified. So, except for Section 28, which is very similar to, for example, the United Nations Conventions on the Rights of the Child, we have legislation, for example, the Children's Act, which helps us and the state and the parents and the child to make sure that these rights can be accessed by all children. Okay, now we move on to Section 27.3 in your textbook, which is the right to a name and nationality. Now, this is found in Section 28(1)(a) of the Constitution, which states that every child has the right to a name and a nationality from birth. Now, the constitutional protection of a child's right to a name and nationality, and the right to have his or her name and other basic family information registers, compromises a child's right to legal identity. Now, this right starts from the moment of birth. Now, it might seem like a silly thing, having the right to a name, because it's something we take for granted. Everyone has a name. But what you should remember is the importance of a name is much more than simply being called something. So why is this so important? The reason being it provides a child with legal identity. It also has important physiological and emotional and psychological connections for a child because it's what connects you to your parents. Your name and surname is what connects you legally to your family. Now, if we say that it gives a child legal identity, what are we referring to? Well, the moment your parents register your name, you become part of the population register, which means that you then can have access to social grants, education, healthcare, social services, and participation in civil and political community. What this basically means is if you do not get registered, you technically do not exist. Now, if you're going to choose a life of crime, that might be something that may help. But for a normal, everyday citizen, if you are not registered at birth and you don't exist, it means when you turn 16 or 18, you cannot apply for an identity document. If you become unemployed, you cannot apply for any help from the government. When you have a child and this child is not registered, it means when they go to primary school, they won't be given access because there's no proof that they exist. There's no proof that they are a citizen of our country. This right can again similarly be found in the UN Convention on the Rights of the Child, which states that every child has the right to an identity, including a name, a nationality. Now, a name and nationality is especially important in the case of adoptions. Section 242, subsection 2b of the Children's Act 38 of 2005 provides that an adopted child's surname at birth is to be changed to that of the adoptive parent or parents, unless the court orders otherwise. The adoptive parents must then apply to record the adoption, and any change of surname to be recorded in the birth register. All adoptions that take place in South Africa are also entered into the adoption register. So that means when a child turns 18 and they do decide that they want to search for their their biological parents, there's a national register which they can apply to, which will indicate to them what their original surname at birth was. This makes the whole process of finding their biological parents and many parts of their identity an easier process. And this is something that not many countries have, and yet again makes the whole constitution and the protection of child in South Africa very unique. The next right we will be doing is the right to a nationality. Name and nationality obviously go together. So the right to nationality is a traditional right for children, and it's found in several international instruments. The importance of nationality is to prevent statelessness. This is a situation where a person does not belong to any specific state. So it's where a person is, when you ask them where are you from or which country are you from, they cannot answer you because they belong to no country. And that obviously means that there's no protection from any country. It is also there to give you the right to vote and the right to live in a particular country. Now in South Africa, we used to have during the apartheid era the TBVC states, which is the states of Transkei, Bophuthatswana, Venda, and Ciskei. Now this is the fact that we have these states is one of the many reasons why the right to a nationality is such an important thing in South Africa. For a long time, this homeland policy ensured that people that were part of the TBVC states were not considered South African citizens. So you were considered to be a citizen of the state of Transkei or the state of Venda, which meant you had no political or civil rights, you had no South African passport or protection. Now nationality is attached to birth. So the Constitution is seeking to prevent a repetition of this exercise of denationalization by attaching the right to nationality to a person's birth. Children are also citizens and therefore also protected by citizenship rights, as found in Section 20 and 21. So they can remain legal. This brings us to Section 27(6), which is the right to basic nutrition, basic healthcare, and social services. Now, in the South African Constitution, in Section 26, we get the right to housing, and in Section 27, we have the right to healthcare, food, water, and social security. But these are the rights for everyone, so it doesn't make any specific reference to children. These are rights that all citizens of South Africa have. Also, these rights are called access rights. Now, what do we mean with this? If you would look here in Section 26 and 27, we have the words have access to and have access to. So it's the right to have access to something. It's not an immediate right. And it's also a right that you have within its available resources to achieve progressive realization of this right. You'll see this in both rights. So what Section 26 and 27 is telling us is that these rights are not immediate rights. There's no claim on the state to give you access to these rights or to fulfill these rights immediately. The only duty on the state is to make sure within the resources that are available, so the money it has, to achieve the progressive realization. So continuously the state must try to give people this right. So for example, if we have the right to water, which is an access right, It does not mean that every house in South Africa must have running water. It says that they must have access to running water, which means if there is a tap somewhere near their house with water, they will have access. And as long as the state is trying within the available resources to give everybody running water, it would imply that the state is fulfilling its duty. So Section 26 and 27 are access rights. This differs from Section 28(1)(c) in the Constitution, which is the rights of children to these same basic rights, housing, nutrition, and such. You will see in the next slide, these are actually... Okay, so now we're here at Section 28. Now, if you look at Section 28, the difference is nowhere in this section you will find the word access to. You will also nowhere find progressive realization or that the state should try within its available resources to give access to these rights. So there are no internal qualifiers and there are textual differences between Section 28 and the previous two sections that we looked at. So what this means is that there is a direct duty on the South African state to ensure that all children must have their socioeconomic rights met immediately. So all children have an immediate right to basic nutrition, shelter, basic healthcare services, and social services. So the difference would be you as an adult can go to the state and you will tell them that you don't have basic nutrition. That would mean that the state's duty will be to say, but we do have, for example, socioeconomic projects, soup kitchens and such that gives you access to food. And we're trying to progressively make sure that we give enough social grants so that everybody has access to nutrition. That is what an adult would do. A child, on the other hand, has an immediate right to basic nutrition. So a child is not supposed to go hungry. The state shouldn't say, we're trying to give children food. Children should immediately have enough nutrition. They should always have shelter and basic healthcare services as well as social services. So that's the difference between an access right and an immediate right. Children will always have immediate rights to socioeconomic rights because they're vulnerable. They cannot go to... In the case of government body of Juma Masjid Primary School, you don't need to know the facts of this case. This is just explanatory to what we just did. So in this case, the judge determined, the court actually determined that it's important for the purpose of this judgment to understand the nature of the right to basic education. Remember, basic education is also part of the basic rights of a child. Now, basic education is found under Section 29(1)(a) of the Constitution. They said, unlike some other socioeconomic rights, this right is immediately realizable. There is no internal limitation requiring it to be progressively realized within available resources subject to reasonable legislative measures. So what the court is doing here is it's comparing rights as found in Section 26 and 27, adult rights, to the rights of a child. Basic education is not a part of Section 28 but Section 29. They're saying the right to basic education in Section 29 may be limited only in terms of a law of general application, which is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. So where access rights, as found in Section 26 and 27, can be limited by budgetary problems, immediate rights, as in Section 29 and Section 28, can only be limited in terms of general application. The state is, in terms of that right, obligated through reasonable measures to make further education progressively available and accessible. So that's the difference between basic education and further education like tertiary education. Now we are specifically moving to the socioeconomic rights of children. Now the first two cases that the Constitutional Court had to deal with children's socioeconomic rights were the Government of the Republic of South Africa versus Grootboom, which was a case about housing and informal settlements, as well as Minister of Health versus Treatment Action Campaign, which was about access to antiretroviral medicine. Now, in these two cases, the only thing you don't need to know the details of these cases, but you need to know that the court used the reasonableness test to determine whether the state has actually fulfilled their duties or not. Remember, we've done the test of reasonability. So an analysis of its relevance to children's socioeconomic rights rests mainly on the requirement that a reasonable policy should not exclude a significant segment of the population, especially not those whose needs are the most urgent and whose ability to enjoy all rights are most in peril. That's why we use the reasonableness test, is that we must make sure that the decisions that the state is making is not excluding a large segment of the population. So if children don't have access to shelter, for example, that's a large segment of population, and children are in need, and their needs are most urgent, and their ability to enjoy all other rights are most in peril because children cannot fulfill their own rights. In both these cases, the court found that the state was not fulfilling its obligations. Interestingly enough, as academics and activists have been somewhat disappointed by the facts that the court in both these cases largely avoided basing their decisions on Section 281C of the Constitution, but rather focused on the rights afforded to all in Sections 26 and 27. So the court used the adult rights, everyone's rights, to determine whether the state was fulfilling its needs and not Section 28. Now, the rationale of the court behind this was while a child is living with their parents, they must first look to their families for the provisions of socioeconomic rights. So in the Grootboom case, where the court had to decide whether the state had an obligation to give housing to citizens of an informal settlement, they said yes, housing must be given because according to Section 26, you have a right to housing. They made no specific reference to a child's right as in Section 28. But this was later adjusted positively in the treatment action case. Here the state determined that the state is obligated to ensure the protection of children's rights when the implementation of the rights to parental or family care is lacking. So whilst Grootboom had stated that children living with their parents will have to look to their parents rather than the state for the fulfillment of their rights, this position was adjusted in the treatment action campaign. Here the court based its findings on Section 27 but utilized Section 28(1)(c) to adapt. So if we use this very basic illustration, in the Grootboom case, the court decided that where parental care, where there are parents, children must look to them. If we move to the next one here, Minister of Health versus Treatment Action Campaign, the court determined even in cases where there are parents, but the parental care is lacking or absent, children do not have to look to their parents for their socioeconomic rights, but they can look to the state. So the big difference is in Grootboom, where there are parents, whether they're good parents or bad parents, you have to look at your parents to take care of you. Whether they have the money or not, you have parents, they have to take care of your socioeconomic rights. The adjustment in the treatment action campaign is even when we do have parents, if their care is lacking, it will be the job of the state to take care of the children. One last part of the socioeconomic rights of children is the socioeconomic rights of children that are actually separated from their parents. And in South Africa, we have a lot of child-headed households, which means that people younger as 18 have their own households. You sometimes have a household where a sister of, let's say, 12 or 14, because she's the eldest, is actually taking care of her siblings. Now, there's been 2 cases since Grootboom and TAC. These cases first was about unaccompanied foreign children, and the other were children in schools of industry. The important thing to know here that is in both these cases, the court emphasized the fact that if children are not living with their parents, they have a direct and immediate claim on the state for the fulfillment of their socioeconomic right. The next right we have is the right not to be subjected to neglect, abuse, or degradation. This can be found again in Section 28, Now, remember we spoke earlier about Section 28(1)(b), which gives the right to family care or parental care. The problem is that the family is not always a safe place for a child. This is why Section 28(1)(d) was written, so that children can be protected against abuse. The protection of the child's right not to be subjected to neglect, abuse, or degradation is a domestic reinforcement of Article 9. If we look at this right, we have Chapter 7 of the Children's Act, which was written to fulfill a child's constitutional rights as Section 28(1)(d). So Chapter 7 of the Children's Act provides special measures for the protection of children, including a reporting requirement for a long list of professionals who, if they conclude on reasonable grounds that a child has been abused, physically, sexually, or deliberately neglected, they must report that conclusion to the Provisional Department of Social Development or to the police. Now, a list of these professionals, an example would be educators, so teachers, kindergarten teachers. Doctors, for example, also have an obligation, a legal obligation to report any type of abuse. Also, in Chapter 7 is the establishment of a register of persons unsuitable to work with children. This aims to prevent people found guilty of abuse from having direct contact with children. So, let's say the teacher is found guilty of abuse, that means that they will not be able to work with children again directly. Then in Chapter 9 of the Children's Act, legal machinery is given to determine whether a child is in need of care and protection. So what Chapter 9 determines, that is, a social worker must investigate circumstances of abuse within 19 days of the report. So if a teacher reports abuse, the social worker has 90 days to investigate the report. And if the social worker feels that these circumstances require it, a children's court hearing will be held. Then during this court hearing, the court will decide whether the child is in need of care and protection. And then the court can make a variety of orders, ranging from leaving the children with their parents or using other services, other family members, placing the child in alternative care. If, when the first report is made, a child is thought to be in need of emergency protection and removal pending the investigation, a court hearing is the only way to ensure the child's safety and well-being. A removal of the child and placement in temporary safe care is permitted by this Act. So the Children's Act is used to give effect to Section 28(1)(d) of the Constitution by first thus giving a duty to certain professionals to report it, to register people that are unsuitable to work with children, and then it gives a power to a social worker to investigate abuse, to take it to court, and for the court to then to actually remove a child from situations where they are being abused. The next one is sexual abuse of a child. In South Africa, sexual abuse of a child is a very, very big problem, with some statistics stating that 1 in every 4 children are abused. If you look at these stats, these are worldwide stats. They say most 20% of children who are sexually abused worldwide are abused younger than the age of 8. 90% of child sexual abuse victims know their abusers, and 1 in 10 children will be sexually abused before the age of 18. This especially places a duty on the state to protect children from their own caregivers. Now, this can be found in the Criminal Law Sexual Offences and Related Matters Amendment Act. It provides for reporting of sexual abuse, and it also widened the definition of sexual abuse. Rape, for example, is not now just sexual penetration with genitalia, but it is also now sexual penetration and includes both vaginal and anal rape of either gender with any object. Many children are sexually abused not actually with the genitalia of an adult, but with objects. And this was for a very long time not seen as technically as rape because it did not fall under the definition of rape. It also now includes making, showing, or distributing child pornography and the sexual grooming of a child. Also introduced the idea of a register of sex offenders. Part of the physical abuse of a child is corporal punishment, something that is quite widely practiced in South Africa amongst many different cultures. Court in State v. Williams and State v. Christian Education Act found that corporal punishment is unconstitutional because it's against the right of a child to be protected from maltreatment, neglect, abuse, or degradation. So legally, no physical abuse can ever be committed against a child. So any type of punishment which requires physical abuse, even just the lashing, is still corporal punishment and is still illegal. This brings us to the next section, section 28.2, which is the best interest principle of the child. So in section 28.2 it says a child's best interests are of paramount importance in every matter concerning the child. Now this was established already in 1940, but it was limited to family law and care proceedings. Today it follows the lead of international instruments and it expands the meaning and the application to all matters that have to do with a child. Now section 28.2 is both a principle and a right. Firstly, let's look at it as a principle. As a principle, it develops the meaning of some of the other rights of the Bill of Rights. It determines the ambit and limits other competing rights, and it's important for the interpretation of rights. As a right, it is a right in itself. It is of paramount importance, so it does not automatically override other rights, and it's still capable of being limited. Even though we have the words paramount importance, it does not say it overrides all other considerations. But when a case, any kind of case of a child right, is before a court should also always consider the. In the case of Minister of Welfare and Population Development versus Fitzpatrick, this case was about allowing non-South African citizens to adopt South African children. The Child Care Act usually declared that it was invalid for a non-citizen to adopt a South African child. But this was then, based on Section 28.2, made invalid because it is in the best interest of the child if they can have a good home, even if it's by someone that's a non-citizen. If they can have a good home, it's still in their best interest. So Section 21.8.2 requires that the child's best interests have paramount importance in every matter concerning the child. The plain meaning of the words clearly indicates that the breach of Section 21.8.2 cannot be limited to the rights enumerated in 1 and 2, but must be interpreted to extend beyond these provisions. It creates a right that is independent of those specified in 21.8.1. So the best interest of the child is not an exhaustive right just for 28.1. It is a right. Now the limitation of rights and the paramountcy principle. Now Section 21.8.2 is used to limit rights. Now, as we've said, the word paramount does not mean it cannot be limited. What it does mean is the single most important factor to be considered when balancing or weighing competing rights concerning a child. But this holding was overruled by the Constitutional Court. The Constitutional Court found that it does not trump other provisions of the Bill of Rights, because that's an alien approach to be adopted by the Constitutional Court, because all rights are mutually interrelated and interdependent and form a single constitutional value system. Thus, the Court stated that Section 21.8.2, like the other rights enshrined in the Bill of Rights, is subject to limitations that are reasonable and justifiable in compliance with Section 36. As a conclusion of this lesson, I want you to go to page 622 and actually read what Judge Sachs had to say about the best interest principle. And what I've given you a summary here of what's been said. You need to understand what the best interest principle means and what its ambit is, according to Judge Sachs.